And now it's time for another case law update. Today's update covers Heppner versus United States, a confidentiality dispute arising out of the Southern District of New York. Let's dive in. In October of 2025, a grand jury in the Southern District of New York charged Heppner with securities fraud, wire fraud, as well as conspiracy to commit these crimes. These charges arose from Heppner's alleged misconduct as an executive of several corporate entities, where he allegedly defrauded investors out of more than $150 million. In connection with these charges, the government searched Heppner's home and seized 31 documents containing communications between Heppner and Anthropic's generative AI platform, Claude. Heppner, without any suggestion or counsel from a lawyer, prepared reports that outlined the facts of his case and the law the government might argue in response. Heppner argued that these 31 documents were covered by the attorney-client privilege and that the government could not view them. The issue before the court was a first-of-its-kind question: whether, when a user communicates with a publicly available AI platform in connection with pending criminal investigation, the user's communications are protected by attorney-client privilege or the work product doctrine. In sum, the court held the answer was a resounding no. To establish the attorney-client privilege, courts analyze whether communications between a client and his or her attorney are intended to be, and were in fact kept, confidential for the purpose of obtaining or providing legal advice. Heppner argued that his documents were protected by attorney-client privilege because 1. He inputted the information that he learned from counsel. 2. He created the AI documents to speak with counsel to obtain legal advice. And 3. He subsequently shared the contents of the AI documents with counsel. However, Heppner admitted that he created the documents himself without his lawyer's advice. The court held that Heppner's communications with Claude were not covered by the attorney-client privilege. First, the court explained that Claude, an AI platform, is clearly not an attorney. The court reasoned that, for privilege to apply, there must be a trusting human relationship with a licensed professional who owes a fiduciary duty and is subject to discipline. Second, the communication between Claude and Heppner was not confidential, as Anthropic, Claude's maker, has a written policy that allows Anthropic to disclose user data to third parties, including the government. Furthermore, AI users do not have substantial privacy interests in their conversations with a publicly available AI platform. For these two reasons, Heppner could not have had any expectation of confidentiality in his communications with Claude. A third reason is that Heppner communicated with Claude on his own, rather than at his lawyer's suggestion. Claude, again, is clearly not an attorney and cannot provide legal advice. It even provides a disclaimer when users input legal inquiries. Finally, the court explained that even though Heppner later shared these documents with counsel, non-privileged documents do not magically become privileged merely by sharing them with a lawyer. The court went on to state that the work product doctrine also did not apply to Heppner's AI documents. The work product doctrine protects materials prepared by or at the behest of counsel in anticipation of litigation. Because Heppner conceded that he did not create the documents at his counsel's behest, but instead did so on his own, the court ruled that the work product doctrine did not apply. So why does this matter? People use AI to solve all kinds of problems these days. In case you already didn't realize it, this case makes it clear that communications with publicly available AI platforms are not a substitute for communications with counsel. Privilege attaches to a confidential relationship with a licensed attorney, not a machine. If you find yourself with legal problems, reach out to licensed attorneys, not AI. We here at RRNA can help, and your communications with us are confidential and privileged. That's all for today. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help with this update.